Hi all, welcome to the A-Level Law Essay channel. In this episode, I'll be covering a past year papers question 4 from 9084/42, paper 4, Law of Tort, May-June 2019. Please note that this video tutorial is a 3-part series. This being part 3, I will be going through with you the essay sample to answer the question. If you have not watched the video reviewing this question and its marking scheme, it is recommended that you do so before continuing with this video. You may click on the card above or the link in the description below this video to check out part 1 past year paper question review for this question. Before I begin, please subscribe to my channel for more video guides on essay writing and many other interesting topics. With that said, let's get started with part 3 essay sample of video tutorial number 14. Question. The question reads: Julian, his wife Helen, and their 4-year-old child Oliver are staying in a cabin at the XYZ holiday park. On the first evening, Julian sustains a head injury when he falls on the steep steps up to the door of the cabin. There is no handrail and the light above the door is not working. There is a warning sign near the steps, but Julian cannot read it in the dark. The following day, whilst Julian is being treated at the hospital, Helen lets Oliver go to the children's play area alone. The climbing frame in the play area is damaged and a sign has been placed on it stating, "Danger, do not use." As Oliver starts climbing on it, a large section becomes detached and he falls to the ground, sustaining a broken leg. Advise the parties as to their rights and responsibilities in this situation. 25 marks. To answer a scenario-based problem question, it is important to first identify the relevant parties and the issues that they are having with each other. From the scenario, we know that the disputing parties are Julian against XYZ Holiday Park and Oliver against the hospital. Julian sustains a head injury after falling on steep steps with no handrail. Even though there is a warning sign, he couldn't see it because it was dark. Oliver broke his leg in a play area that was damaged. A danger sign was placed there, but it was completely ignored as he went to play by himself. Now, we are to advise all the parties involved in this incident. After identifying these important things, we should then be able to figure out which chapter in the Tort Law syllabus this question is covering. By the looks of some of the key points in the scenario, it is safe to say that it covers the chapter Occupiers Liability and that it focuses on both visitors and trespassers, factoring a child, and also the argument of defense. With these topics in mind, we now have to consider the rights and liabilities of all relevant parties in this situation. Before I begin going through the essay, I would like you to note that my answer is not the perfect essay answer, but it only serves as a guide for you so that you get an idea on how to write your essay and score the highest mark possible for your effort. Incidentally, I may have also left out certain minor details from my content video, as whatever points that have been discussed earlier only serves as a guide for us to reach our end product, which is the essay. One more important thing to note is that since, for examination purposes, the time limit for one essay answer is exactly 30 minutes, I will not have a lot of time to cover every single relevant detail, and the ideal word count for an excellent essay answer is between an average of 700 to 900 words per essay. Introduction. People can get injured anywhere due to the state of the premises for which they are in, and people who own the place are often made liable for the injuries sustained on their premises. To determine if Julian and Oliver can claim anything for their injuries, we need to establish that both the park and hospital are liable as occupiers of those premises under the Occupiers Liability Act 1957 and 1984. Point 1. Body Paragraph 1. Occupiers Liability is governed by both the 1957 Act and the 1984 Act, where the former covers visitors while the latter covers trespassers. Both acts impose a duty of care upon the defendant occupier towards people who get injured while on the occupier's premises. Common law defines an occupier as one who has sufficient control over the premises as per the case of Harris v. Birkenhead Corporation, 1976. Therefore, with no other evidence to suggest otherwise, it can be established that both XYZ Holiday Park and the hospital are both occupiers of their respective premises. The real issue now is whether or not these defendant occupiers are liable for whatever injuries that the claimants have sustained. Point 2, body paragraph 2. A visitor is someone who has expressed or implied permission from the occupier to enter and be on the premises. Applying this to the fact, Julian is undoubtedly a visitor in XYZ Holiday Park's premises, and Section 2 Sub 1 and Sub 2 of the 1957 Act provides that occupiers of the premises owe visitors a common duty of care in all the circumstances is reasonable to ensure that visitors are reasonably safe while on the premises. The facts clearly state that the steep steps up toward the door to the cabin is without a handrail, and that the light above the door is not working. In Ward v. the Ritz Hotel 1992, it was stated that by not complying with regulatory safety standards on hotel premises, there is strong evidence that the hotel did not take reasonable care that is required by the Act. Therefore, by applying this argument into the facts, it is possible to say that it is unreasonable for there to be an absence of a handrail on steep steps, especially when there is a need for strict safety standards on such premises. Point 2, body paragraph 3. The park might want to argue that there is a warning sign there to ensure visitor safety. Section 2 Sub 4 Sub A of the 1957 Act states that if an occupier gives a visitor sufficient warning of a danger to render visitor reasonably safe, the occupier will not be liable for any damage suffered by the visitor. However, the case of Ray v. Mars 1990 states that a warning is not enough if the premises were to be particularly dangerous, that no amount of warning can keep the visitor from injuring himself. Because the area was dark as the light above the door is not working, it should cancel out any effect of the warning sign. And looking back at Section 2 Sub 4 Sub A, the absence of the light would make the sign irrelevant, and so the warning would not render the visitor reasonably safe at all. Therefore, overall, it is possible to say that the park is liable for the head injury sustained by Julian. Point 3, body paragraph 4. Being on hospital grounds as well as the play area also makes Oliver a visitor, but as soon as he climbed onto a damaged frame within the play area that was labeled with a danger sign, he would be considered as a trespasser. A trespasser is someone who enters onto premises or parts of premises without permission, and whose presence is either not known to the occupier or is objected to. The case of Tomlinson v. Congleton Borough Council 2003 states that a visitor can become a trespasser when warning signs are deliberately ignored. However, at the same time, Section 1 Sub 3 of the 1984 Act also dictates that the occupier must have reasonable grounds for believing that a risk of danger exists and that a trespasser is in the vicinity. Therefore, applying these principles into Oliver's case, it is safe to say that he is a trespasser. But the next question is whether or not the hospital should be liable for the injury sustained by Oliver. Point 3, body paragraph 5. Oliver is a 4-year-old child, and so we need to consider Section 2 Sub 3 Sub A of the 1957 Act, as it points out that the occupier must be prepared for children to be less careful than adults, and if the occupier allows a child to enter the premises, then the premises must be reasonably safe for that age-appropriate child. According to Jolly v. London Borough of Sutton 2000, children typically show considerable ingenuity in finding ways to put themselves in danger. Thus, greater care is necessary to ensure that children are reasonably safe especially when the danger can act as a form of allurement towards children, as seen in the case of Glasgow Corporation versus Taylor, 1922, i.e., the play area for children. However, an occupier can also assume that very young children are accompanied by someone looking after them, as seen in Phipps versus Rochester Corporation, 1955, and so absolving them from liability. Therefore, if we were to use this argument, it is possible to absolve the hospital of liability unless Oliver can argue negligence and say that the hospital owes him a duty of care which has been breached and caused damage to him. Conclusion. Based on everything that has been discussed, it is possible to say that XYZ Holiday Park is liable towards Julian's injury. However, as for the hospital's liability towards Oliver's injury, it is hard to conclude, since there is the issue with the warning as well as the fact that Helen should have been more responsible towards her son. This is the end of the essay sample for this video tutorial. If you have any questions or opinions on my approach to answering the question, please do comment below. Do check out part 2 of this video tutorial for a proper content guide on how to answer this question. I will put a link to it in the description below. If you find this video tutorial useful, please like, share and subscribe to my channel for more. Thank you for watching, and I'll see you again next time.